Welcome to another Radar Talks. This morning I'm here with Rob Horne, partner of Simmons Simmons, and we're going to be discussing the role of contracts within the creation of collaborative cultures. Good morning, Rob.
Good morning.
What we want to try and discuss here is the role of contract within a collaborative culture. We're hearing more and more about projects being delivered using collaboration, at which point what's the purpose? Where does the contract fit into this?
I think it's an interesting question. It's difficult to answer. I think lawyers get understandably overexcited by writing contracts. It is what they're paid to do. Equally, delivery teams try to ignore contracts because they're not there to write the contracts, not really interested, they want to deliver a project. And there's often a disjoint between the two. As soon as you end up with a disjoint between the two, you don't know what you're collaborating on the basis of. So you might know your output, but you don't know your input. As soon as you don't know both halves of the equation, you run a risk of having a problem on the project.
And so in there, the purpose of the contract is to get full alignment on what the inputs are and what it is that you're going to collaborate around.
Yeah, I think so. It really is defining what the input and the output is going to be. So you understand everything about the project in a recorded way that doesn't change, as people's memories tend to do.
And do you see from the side that you look at it, obviously from the contractual point of view, is there a difference between the different forms around that process and aiding collaboration?
That's a really difficult question, funnily enough. Lots of contracts deal with the collaborative element in a different way. So you have forms like the PPC form of contract, which is very focused on partnering. You have NEC, which is very focused on the parties working together with mutual trust and cooperation, all the way through to the FIDIC style contracts where they don't really have any interest in working collaboratively and just do what you are told to under the contract. So the contract drafting is quite different. Does it make a difference to delivery though is the real key point, and I don't think that it does necessarily. That's driven as much by what's in the contract to start with, but also mixed with the people on the project and how willing they are to enable those contract terms to be brought into effect.
So, I mean, we hear, I suppose, a lot of use of particularly NEC3 because people want a collaborative contract or want a collaborative project.
Yeah.
So perhaps the reality being that it is the desire of the parties to create the collaborative culture that leads to that, and they have selected NEC3, for example, because they believe that it helps support collaboration, whereas those same people could well have created the same collaborative culture using a JCT, but still behaving in a collaborative form.
Yeah, I think that's right, and I think, funnily enough, that the inverse is also true. That if you haven't set the collaborative culture or the collaborative intent properly at the outset, it doesn't actually matter what form of contract you use. So some of the least collaborative project teams that I've seen have been under collaborative forms of contract, whether it's NEC, PPC, whatever. And I've seen very good collaboration under FIDIC forms, where there is no overt use of collaboration or working together at all. I think once you go outside the UK, there's a whole different range of things to take into account where you do have underlying legal obligations to act with fairness and those sorts of concepts come in where they're not really apparent in the UK law.
And I suppose that's the next stage, and sort of in our conversation as well, of how and can you contract for collaborative behaviour, and is it appropriate to try and bring that element into a contract rather than using the contract to cement those inputs and outputs?
I think there's a couple of issues in there. One, lawyers are not very good generally at dealing with the softer side of how you run a contract. They're very good at mandating you must do and you must not do. But when it comes down to the softer, collaborative, working together elements, one, it is very hard to draft contracts that really capture the essence of that. And two, I'm not sure that it can be drafted, and the harder you try to mandate working together, the more likely it is actually that you're going to push the parties apart by over-legislating, if you like, for the minutiae of how you deliver the project. Whereas what you need to do is have a baseline which is captured with your contract, which shows what you're going to put in and what you're going to take out in terms of the project. But how you do it is much more soft skills, getting people together in the right sort of training environment, which is separate from the contract.
So, sort of taking that on then, the sort of advised approach may be to utilise the contract for what it is best used for, which is, as you say, stipulating the in detail the input and the output, and keeping a cultural creation to just that,
Yes.
and doing that via, as you've put it, the soft skills of the project team, rather than even trying to mandate them.
I think so, because as soon as you put something into the contract, it has to have legal force. Otherwise, what's the point in having it in the contract at all? I think that's the point. A lot of people who are more interested in the project delivery forget that actually what goes into your contract could appear in front of a judge for you to enforce through a court of law. So if you've got something in your contract which is incapable of enforcement because it's all about soft skills and working together in the UK, where we don't have this idea of fairness and collaboration as a legal principle, if you have that in your contract, what's a judge going to do with it? And the first thing they will do from the case law is they'll put a red pen through it and say, well, it's all very interesting, and that might have been what you intended to do, but you're not actually bound to do it. And as soon as the judge starts putting a red pen to your contract, you don't then have clarity and certainty of your inputs and outputs, which is the whole basis of having the contract in the first place. So real care over what you put in terms of, can you actually enforce it?
And I suppose equally then, to not rely on a collaborative culture to be the answer to all of the problems, and make sure that as you are signing up to the contract at the start of the project, that those inputs and outputs are fully understood and are properly articulated, so that all parties really know what it is they are collaborating around achieving.
Yeah, that's exactly it. I mean, you can't have a conversation without context. You can't work out what project you're going to deliver unless you know where you're starting from and where you're trying to end. The collaboration is just the how you do it, not the what you're doing.
So, as opposed to there being no need for a contract in a collaborative project, we would say that in actual fact it's a necessity to have both a contract to provide the starting point, to provide the context around which a collaborative culture can be created, and therefore to achieve a successful project delivery.
Yes, that's exactly it.
Excellent. Well, Rob, thank you very much.
Thank you.